Welcome, everybody. Today I want to talk about a case where the ICE is terminating F-1 student visa for a speeding ticket. I mean, it's crazy times because just for a speeding ticket, they terminated SEVIS and the F-1 visa. Let's take a look at this case. So this was filed at the U.S. District Court in the District of Columbia, and this is the plaintiff, and this is the defendant. So let's just go through. It's a long case, but we can just go through this. So the defendant, ICE, U.S. Immigration and Customs Enforcement, sought to make good on the current administration campaign to promise to be tough on criminal aliens through any means possible. So this time, to be tough on crime, they targeted international students in the U.S. And it claims had criminal records. So we're going to take a look at this case and see why this person did not have a criminal record. He had a speeding violation or a speeding ticket or arrested for speeding, but there was no case, there was no charge, there was nothing. I simply terminated these students' record in SEVIS. So what is SEVIS? It's an online database that houses information on international students. And because they terminated SEVIS, they terminated the students' immigration status as a lawful student. And they're saying that this act, however, terminated the status of students with no criminal record, like the plaintiff, for reasons below. We're going to talk about those reasons. And the attorney for this student is saying the court must set aside the termination of the plaintiff's SEVIS and his F-1 status to prevent irreparable harm. So the parties are, here's the plaintiff. He's a citizen and national of India, and they named quite a bit of defendants as usual. And they're saying that the court has jurisdiction. And here are some of the facts. So the facts are this person is a citizen of India. He is accepted into a university, and he applied for and acquired F-1 student visa. He attended an interview in the U.S. consulate in India, and the U.S. Department of State issued him a F-1 visa. And so when it comes to F-1 visa, it is good for the duration of the status. So they define the duration of the status here. It says, it's for an F-1 student. Duration of status is defined is at a time during which an F-1 student is pursuing full course of study at an education institution like the university, and certified by SEVP for attendance by foreign students, or engaging in authorized OPT, practical training, following the completion of studies. And then the student is considered to be maintaining their student status if they're making normal progress toward completion of a course of study. So because a degree programs differ in length from program to program and school to school, F-1 students are generally admitted for the duration of their student status. So here's what they have in terms to monitor that. To monitor and verify the F-1 student don't overstay the status, U.S. Immigration and Customs Enforcement operates something called Student Exchange and Visitor Program. It's called SEVP, Student Exchange and Visitor Program. So SEVP in turn certified schools to accept F-1 students. To qualify for SEVP certification, schools must agree to report, update, and maintain information for each F-1 student in that database. And that database is called SEVIS. So basically, SEVIS is nothing more than an online database housing data for F-1 students. And the school is required to report certain events on SEVIS, like their start date, course progress, graduation. In turn, the SEVP monitors SEVIS to certify that the F-1 students are maintaining their status. So the regulation defines maintaining status for F-1 students making normal progress towards completion of study, like we already saw. So if a student quits school, they have something called a DSO, something called designated school officer. They report the early withdrawals in SEVIS and terminates the SEVIS record. So depending on the reason for termination, ICE considers a student with terminated SEVIS record as a non-immigrant. So if you have a terminated SEVIS record, you're non-immigrant without status that is present in the U.S., and ICE expects these non-immigrants to leave the U.S. For an F-1 student's SEVIS record, the F1 status can be terminated for a limited number of reasons. And without a SEVIS record, a student cannot have an F1 status. By the way, if you like I guess the videos that we talk about immigration status, the I-130 delay, just give me a thumbs up, because the algorithm tend to pick up and show the videos to other people when you give a thumbs up. So I appreciate you giving a like. And okay, let's just continue this. So first, the DSO can terminate the SEVIS record and the F1 status if the student does something wholly inconsistent. So they do something wrong, and we're going to define what that is when they're making normal progress toward completion of the course of study. So here are some of the things that they can terminate the SEVIS and the F1 status. So if they have any unauthorized employment by a non-immigrant, so if they have any unauthorized employment by a non-immigrant, constitutes a failure to maintain status. And also any type of conviction in the U.S. For crimes of violence, that the SEVIS and the F1 can be terminated. And then finally, the ICE believes F1 student has failed to maintain their student status. It can place a student in removal proceeding. So then they're talking about the plaintiff. So the plaintiff timely started classes, undertook a full course of study, and then something happened while on break. Looks like in November of 2018, he was arrested for recklessly driving a motor vehicle due to high speed in Texas. So he was speeding in Texas, and he was arrested. But what happened is the assistant DA in that county moved for a dismissal, and it was granted. So he was never prosecuted for this crime. He was speeding, and he was arrested for speeding in Texas. That is, that itself is questionable, right? A lot of people speed, but this immigrant speeds and he gets arrested in Texas. Okay, but that's besides the point. And then he continues his studies and has one exam remaining and anticipate graduating in a month. However, the DSO at the school notified him that his SEVIS record has been terminated. The letter reports that the ICE terminated his SEVIS, and it had the following note: termination reasons: otherwise failing to maintain status, individual identified in criminal record, and check his visa had revoked and the SEVIS record has been terminated. And the ICE website explained there's no grace period for termination for otherwise failing to maintain status. There's the attorney for the student is saying if the government had given the plaintiff an opportunity to respond to the charge of termination, he would have provided the letter from the district attorney in Texas that shows no charges were ever filed for speeding, and that shows that he had no criminal record. But they give him no chance to respond, and at this time, just like a lot of the other students, Department of State has revoked his visa. And revocation of visa alone is not the biggest impact. They're saying that SEVIS termination causes immediate harm and significant harm. So here are the harms that he's going to face. First, according to ICE, he no longer has F1 status because there's no SEVIS, and he must leave immediately or risk detention and physical removal. And second, according to USCIS, he's accruing unlawful presence, which will prevent him from acquiring new visa in the future and can lead to a permanent bar. He can no longer graduate or apply for work authorization associated with his F1 after graduation. And fourth, the ICE claims he has criminal record, and that is stigmatizing him. And even though he doesn't have criminal record, those were dismissed. And ICE claims that he has a criminal record which reflects his moral character and leaves him with stigma associated with criminal record. By the way, when he applies, even if he eventually gets a green card or naturalization, he's going to have to disclose all this anyway. Even if he was never charged, he's going to have to disclose the fact that he was arrested for speeding. And a lot of people speed. I question the fact for an immigrant to be pulled over and then arrested for speeding in Texas. Okay, and anyway, the first causes of action they talked about is the APA, and let's take a look at some of the other ones, and then claim for equal justice. So here's what his attorney is requesting. They're saying that the court take jurisdiction of this case enter a temporary restraining order or a preliminary injunction enforcing the effects of ICE's termination for the SEVIS record and the F-1 status during the litigation, declare ICE's termination decision unlawful, enter an order setting aside ICE's termination decision, and then enjoining ICE from terminating plaintiff's SEVIS record and F-1 status without additional process in the future. Order ICE to pay his reasonable attorney's fees. I mean, this is just, it's kind of ridiculous what is really happening. But anyway, I mean, I'm, again, as a citizen, I have free speech rights, and these are all in the public records. I want to keep looking to see what is happening in immigration with the court, and I'm going to keep making videos about it. Anyway, if you like this, give me a thumbs up, like, subscribe, and it helps for other people to find these videos when you give a like and a subscribe. Thank you very much. Bye-bye.